Would you please give us your assessment of what is happening in the national scene in terms of both implementing and or repealing bilingual education?
Yes, it's sort of painful, but if you've been around as long as I have, you realize that most things happen are sort of on a pendulum, and things swing back and forth, particularly in the civil rights area, but and maybe even more particularly in the education area, where yesterday's innovation is tomorrow's disaster, and tomorrow's innovation will be tomorrow's disaster. Basically, there's obviously has been sort of an anti-immigrant groundswell that long precedes September 11th. That led to a number of states enacting, English as the official language, sorts of constitutional or statutory amendments. They generally had very little impact on education. They were sort of more declarations of sort of breastbeating declarations that English is the official language in the state. But they reflected a feeling. Then, several years ago, California, which sort of always or has historically led the country in terms of sort of grassroots extreme behavior. An article that now in the New York Times, it says Florida has surpassed California in this regard. But California, there's an initiative process, as there are in many places, where you get enough signatures on a proposition, or signatures to support a proposition, you can put it on the ballot. And there was a ballot measure in, I believe in 1998, that basically said that bilingual education, native language instruction, should only be provided if parents jump through various hoops in order to get it. And that passed in California. It is important. I've found that people in Florida and elsewhere often misunderstand these initiatives, in particular the California one, Proposition 227, in thinking that it sort of abolishes all programs for these kids. It absolutely does not do that. Federal law, which I previously talked about, supersedes state law. So if there's a conflict, federal law prevails. So all the principles that I've previously articulated still hold. The obligation to deal with both things. All it really dealt with was native language instruction. The other thing that I think is terribly important to understand is that the California law actually did not bar bilingual education as such. It basically said that if 20 parents in a given school and given grade level want their kids to be educated in their own language, they can sign a waiver, and the school district must in fact deliver a native language program. So that in California, there are in fact significant numbers of bilingual programs. Around the country, these initiatives are, one was passed in Arizona. There's efforts to get them on the ballots in Massachusetts and in Colorado. And who knows what's going to happen. I think ultimately we're going to start seeing a backlash. The Colorado Supreme Court recently, on sort of technical grounds, but I think sort of reflecting an enmity toward some outsider, and this is all being pushed by a group of people who, several in California and several in Massachusetts, who are historical opponents of bilingual education, sort of building upon, obviously, sort of anti-immigrant feeling. But I think that in Colorado, the Supreme Court basically knocked it off the ballot, at least temporarily. And my sense is that that was a feeling that, you know, no outsiders have any business telling us what to do. And, you know, if this were a grassroots movement here, maybe we'd look at it a little differently. I think that this is going to swing back and forth. Native language instruction, at least for kids who have no English language skills, is, to me, it's almost a no-brainer that you ought to be trying to deliver such a program. You know, on the fringes, as kids develop greater English skills, you know, there may be, obviously there are points where you very well may withdraw native language instruction. But my sense is we will see it come back, and we will see it come back substantially.